Hey everyone, it's Brad Pollina and Lee Bergstein at BFKP, and we're jumping on here on Friday afternoon to share the news of a very significant legal development in the world of commercial real estate, a court decision that was just issued this afternoon. Lee, you want to tell us a little bit about the decision?
Sure. So, just a few hours ago, the United States District Court of the Southern District, in the case of Melendez versus City of New York, and the judges, Judge Abrams, declared that the New York City Guarantee Law, which was put into effect during the COVID-19 pandemic, is unconstitutional by virtue of the fact that it violates the contracts clause. So I guess the first place to start is, I'm sure many people watching this know what the guarantee law is, but if they don't, Brad, what's a brief refresher on that?
Sure. So, Lee, as you just said, the guarantee law was put into effect by the city council during the kind of early days of the pandemic. And essentially what the guarantee law says, or I guess said, given today's decision, is that guarantors of certain commercial leases, individuals, natural persons who were guarantors of certain commercial leases would be held, could not be held responsible for rent and other financial obligations under those leases if those businesses were subject to certain closure and in-person service restrictions. Also, the provisions of the guarantee law applied specifically with respect to lease defaults that occurred during a defined period, and that period was March 7, 2020 through June 30th, 2021. So essentially, many commercial leases, the tenant on paper on the lease is an entity, whether it's an LLC or corporation. Often, maybe it's a young company, doesn't have a lot of assets. The landlord will require a person behind the business to sign a guarantee. The guarantee law said was for those businesses that were forced to close or stop serving people in person or limit in-person services, those individual guarantors could not be financially responsible if they defaulted on the lease for that time period that I just mentioned a minute ago.
Right. So this was obviously I don't want to call it a boon, but this was incredibly helpful for many commercial tenants during the COVID-19 pandemic. Has been a defense raised both pre-litigation and during litigation by guarantors. From my perspective, it was a tool that we often use to great effect to assist commercial tenants in either surrendering space early or negotiating abatements, because there was this tool in the guarantor's back pocket. The bottom line is that defense is, for the time being, no longer available, and I'm sure this decision is going to get appealed. How it impacts litigation that's pending or is taking place remains to be seen. But Brad, what's your sense of how it might impact landlords and tenants who have not litigated the issue yet? So, for instance, you have a commercial landlord who was well informed as to the impact of this law, had a tenant vacate the space 5 years early with a guarantor during the COVID protected period. They otherwise fit within the qualifications of the guarantee law. And they said, you know what, I don't want to go spend my hard-earned resources chasing this person because I'm not going to recover anyway. They have this defense available to them. What do you think is going through the mind of a landlord like that and a tenant who had availed themselves of this defense in making the decision to vacate early?
Right. So, I think there are undoubtedly many landlords out there who had leases that were in effect and they were meant to continue during the pandemic, long past the pandemic. And those landlords have lease defaults and rent that they have not collected pursuant to the terms of those leases, right? And those landlords had a choice when this law was in effect. Okay, know that I can't pursue this guarantor. Again, if the lease, if the underlying business was of the type of business that was protected by the guarantee law, a landlord, let's say for certain types of restaurants, for example, landlord might say, well, I'm owed tens of thousands, hundreds of thousands of dollars of rent. I know that this law says I can't pursue the guarantor, but I also know that the tenant, this LLC or this corporation, that's the signatory to the lease. I also know that that's a shell company that has no assets. So there are many landlords out there that essentially wrote off uncollected rent as sort of a cost of doing business, money that they're never going to see. I would say probably the most immediate impact of this decision is that many of those landlords are probably going to re-examine their situations, re-examine amounts that they had assumed they would never collect, and make a determination about whether it's worth their time and money to now pursue individual guarantors that were previously shielded by the guarantee law. I think by the same token, there are now guarantors out there who had assumed that they would never personally be sued because they were guarantors on commercial leases with defaults occurring during that COVID guarantee period. Those guarantors may find themselves now on the receiving end of new demands or even lawsuits from their landlords.
Yeah, I think that's right. So, I mean, look, this again, this case just dropped. I'm sure there's going to be a bevy of analysis in the weeks to come. I think we're going to want to probably dig a little deeper into the decision when we have a little bit more time. So, stay tuned for further updates on it. But certainly, this is going to have a substantial impact on commercial landlord-tenant litigation for the foreseeable future. So we will keep a close eye on it. And happy birthday, Brad.
Thank you. That's maybe the fourth time you've said it, so I appreciate that, Lee.
It's not. It's the first time.
Have a good weekend.